Some additional document, the same similar. The command land we have last week disposed of.
The same.
No, that is to be translated.
No, if you want, you should have first of all, you should have made them on record. But on your request, we can grant you 1 day's time to produce the document tomorrow.
No, madam. Insofar as the NOC is concerned, madam, this is 2000.
Then we will dismiss the petition. The same matter.
Have it there. And that circular answer. I am not simply taking action.
That circular will not improve the case of the petitioner because prior to 12/8/2016.
Unless you are able to show the joint inspection report, nothing is going to help you. And if it had been there, you must have brought it on record. This much we understand.
What inspection, my lord, which is referred. At kindly see annexure H, my lord, everything has been referred.
All right, we will take it day after tomorrow. But
otherwise, I am withdraw, my lord, because I know in case, my lord, if there is no K. Since, my lord, all along joint inspection, my lord,
because what we understand that you are expert on these matters. So if you have not produced the joint inspection report, it means that it is not there.
Since, my lord, I have contacted in the morning that they have said they have applied.
All right. On
have it there.
Notice for the respondent has been accepted by shall be accepted by learned ATA. Learned counsel for the petitioner wants a day's time to file additional documents in order to show that a joint inspection was carried out on the Gomal land. Full stop on his request. Case is adjourned. Day after tomorrow.
Listen, I'm sorry. Since I have contacted today, I am making.
No, it happens. Sometimes the fees of the lawyer is not come. So he wants a day's time so that we understand. So therefore we accommodate the lawyers.
Generally, I will not
instructions.
Still number 2, Raji Kulle.
Please, my lords.
Yes.
So joint inspection was carried out, my lords, on 4/3/2021 for declaring an area as safer zone, my lords. So far, for a period of 1 year, it has not been notified. This is squarely covered up by a decision delivered by this honorable court, copy of which is produced at page number 32, my lord, at annexure D. And covered by
Sound ಬರ್ತಾ ಇದೆ. Radar off ಮಾಡ್ತಾರೆ.
Live streaming, can we stop live streaming because of
Will consider the application of the petitioner within a period of 6 weeks.
Why 6 weeks?
Lord,
So
if there is a favorable joint inspection, Lord, then we have to notify. That's it.
We will grant you 2 weeks time. 2 weeks for two is sufficient.
In accordance.
But if you don't have to do the joint inspection, if it is there, then you have to pass the order. issue the notification. That is all.
In terms of this order.
Not
Please, my
terms of that order, Lord. In that case, Lord, there was a favorable joint inspection. In this case, Lord, we'll consider in accordance with law.
In case joint inspection is there, then you will consider in accordance with law.
Please, that's it.
the page number 36 is the order passed by this honorable court, my
Pass
lord.
a fresh order.
Please, my lord.
In this petition, petitioner is sought for the following reliefs. Extract, it is extract. The heard learned counsel for the petitioner, order
Notice.
sheet only. Learned AGA accepts notice for respondents. Heard learned counsel for the petitioner and learned AGA for the respondents and peruse the material on record. In addition to reiterating the various contentions urged in the petition and referring to the material on record, learned counsel for the petitioner invites our attention to order passed by this court in WP 14298 of 21 and WP 14300. Counsel for the petitioner submits that a joint inspection has already been conducted, and as such, the respondents are to be directed to issue a notification in terms of the joint inspection report. Per contra, learned counsel, learned AGA submits that the joint inspection has not been conducted so far.
It has to be verified as to whether joint inspection.
It's that it has to be verified whether a joint inspection has been conducted or not, and in the event the joint inspection is conducted, if reasonable time is granted, the respondents would proceed to issue a notification in terms of the joint inspection
In accordance with law.
in accordance with law. Said submissions made by the learned AGA is placed on record. In view of the aforesaid facts and circumstances and the submission made at the bar, we deem it just and appropriate to dispose of this petition, directing the concerned respondents to verify whether a joint inspection is conducted and proceed to issue a notification.
If there is a favorable joint inspection.
That's right. To verify whether joint inspection is conducted,
and if there is a
favorable recommendation made in the joint inspection, recommendation made, the respondents shall proceed to pass appropriate orders and issue a notification in accordance with law within a period of 3 weeks from the date of receipt of a copy of this order.
My lord. Please, my lord.
Number 3, Ranganath is Jewish.
Sir, Joy sir, unmute your mic, sir.
I am audible?
yes.
My lord, the petitioner has been working since 2013, my lord. Earlier, the private respondent herein was appointed on a project basis and working from 2006 to 13. But her services were terminated on the ground that there are some irregularity, my lord. Then, my lord, that order was challenged before the single judge, my lord. The single judge, my lord, allowed the petition on the ground of natural justice. So far as my claim is concerned, I am working for 7 years and my probation has been declared and my appointment is in pursuance of a vacant post. All these aspects have not been taken note of. Only direction has been to reinstate. Now, my lord, as a result of which my appointment is at stake, my lord, because I have been appointed. I have produced the documents to show that I have completed the period of probation. As for and the IFR additional documents, I have produced
What is
the
the order
documents.
under challenge?
Order and challenge is dated on a page number 18, my lord. Page number 18, 10/12/2019, by which, my lord, the petition filed by a contract employee was allowed. And as a result, she has been directed to reinstate. Whereas, in the same petition, I am a fifth respondent, my lord. And I have been working on probation, completed the period of 8 years of service.
Page number 18 is in Kannada.
My lord,
Have you
English.
18 page.
18, my lord.
1/8. In this,
My lord, this is the order. Your lordship got it, my lord.
writ appeal. Respond.
Respondents, my lord, in that petition, I am the petitioner, appellant herein. I am appointed on regular basis, my lord. I have produced the IA for additional documents to show that my appointment is in pursuance of a notification, page number 94 onwards in the IA for additional documents. I have produced that my appointment is a regular appointment. Probation has been declared. And because of the order passed by the learned single judge, my lord, there is a threat of my appointment after 9 years. And in fact, the panchayat.
Just a minute.
Yes, my lord. Yes.
Now, who are you?
Well, I am a regular appointee to the post of data entry operator, whereas the respondent was appointed on a contract basis for a particular period. Whereas I have been appointed in pursuance of a notification, my lord. I have produced for documents along with the IA for documents, page number 91 IA, my lord. Page number 91 is my affidavit along with the IA for documents, where all the documents, including the notification calling for.
Whether any writ appeal has been filed by the executive officer Taluka?
They filed a review, my lord. They filed a review only. They have not filed the appeal. The review filed by the panchayat has been dismissed. Therefore, I challenge the order of review and also the writ petition order. But office has raised the objection that you cannot challenge the review order, my lord. That is the office objection.
Sir, the writ petition.
In the leave vacancy in place of the respondent who had challenged his termination. So you do not have any independent right.
No, when that person was appointed, it was only a project. It was not against a post. Whereas for me, it was after due notification against a post, I am appointed. She was only appointed for doing certain work, my lord. Appointment order itself says she was appointed to do certain work, not against any post.
What
Not
is
enough.
this effect of this order is that she stands reinstated.
But by that time,
as if her termination order was not passed.
yes.
Then
But
there is no question of you being appointed.
my lord, I have been working for, that's what exactly I am saying, my lord. Her appointment, because the court learned single judge proceeded as if she is appointed to a post, so that 311 of principles of natural justice is appointed. She was appointed in a project, my lord. Kindly see annexure, the order when she was appointed, how she was appointed, annexure A, page number 42. 42, my lord. It was only and now both are working, but now I have not been terminated. But because of the order of the learned single judge, there is a likelihood of termination. Because as on today, I am also working.
Who appears for the
Panchayat, my lord,
executive officer?
executive officer earlier one. I serve the counsel who appeared for the before the learned single.
You serve copy on the counsel who had appeared
Yes.
on behalf of Chief Executive Officer, Jilla Panchayat.
Not chief executive, my lord. Executive officer, Taluk Panchayat. Executive officer, Taluk Panchayat. And Gram Panchayat. I will serve, my I will serve.
In the writ petition, the designation is shown as Chief Executive Officer. And counsel for appellant shall serve a copy of this appeal to Shri M.N. Madhusudan, M.S. Madhusudan, M.N. Madhusudan, who had appeared, advocate who had appeared for respondent up number 2,
1 and 2.
1 and 2, before the writ court. Give it short date.
Sir, and also this R3,
Or 3.
Mr. Satisha Kane for Subrao and Company.
Twenty-nine is there delay.
Unmute yourself first. You are first unmute yourself.
Lord, even in cases where the Honorable Apex Court ultimately causes a selection or appointment, if the person respondent is working for long period, may not for no fault of his, their right has to be. So status quo as on today, so far as I am concerned, may be granted. As on today, I am working, my lord, please.
Let them appear. Give next week. Give a date.
Yes.
Your Lordship, I appear for the respondent in this matter.
For the appellant, Lordship.
Filed an application for posting. A date may be fixed. We'll argue the matter, Your Lordship.
For the appellant, Lordship. I'm appearing for the appellant, Lordship.
Yes.
I have filed an application for posting, Your Lordship. The date may be fixed.
On the last date, you people informed that there is a possibility of amicable settlement.
Yes, Lordship. We had given a settlement proposal of 6 months' time, considering that I am undergoing a severe economic hardship. My learned friends did not agree to it. Then the whole mediation process did not really work out. But I'm still open for that. I mean, I'm just requesting this honorable court if it could request the respondent. That's all I can say. Hello. Am I audible, Lord?
Suresh.
Hello. Am I audible, Lord?
Just a minute. Please. Yes.
His Lordship, during the mediation process, we had requested rather a settlement proposal of 6 monthly installments, which the respondents have disagreed. My only problem is
What has happened in the mediation?
we gave a proposal that we will repay the amount in 6.
We are not interested in your proposal. We want to know what is the result of
It
mediation.
has failed, Your Lordship.
Failure. It has failed, Lordship.
Where is the order?
Order is in page 20. No, the mediation order.
Where is the order passed in mediation? Whether any mediation was referred or not?
It was, Your Lordship, on 24/11,
Have you
2021.
brought the order passed in the mediation proceedings? All right. Now, what is the matter? It was not, no notice, nothing was done in this appeal.
No, we had filed the appeal and the respondents were served, and after that we requested for the mediation, which has failed. Now they have moved the application for fixing a date for hearing, Lordship. That's very good.
He's saying that since mediation is failed, matter has to be heard in this court.
That is what we want to know, whether any notice was issued to respondent.
They have appeared.
Yes, Your Lordship.
They have appeared, Lordship.
Whether the appeal has been admitted.
No, sir.
No, Lordship.
No, Your Lordship.
Yeah. You were on caveat.
No, Your Lordship. Notice was issued to me and then I appeared. Thereafter, it was referred to mediation.
19/7/21. (19/7).
Yes. All right, yes. Please argue your case.
Yes, Lordship. The matter is basically an appeal from impugned order dated 69/17/2017, against which we won a OS in AS 111 of 2018, wherein in the appeal under section 34 on 19/4/2021, the Honorable Judge of the London Sessions Court upheld the arbitration award. The brief facts of the matter.
The arbitral proceedings. The ex parte award by the tribunal confirmed under section 34 before that.
What can be done? What is done? You had filed 34.
Yes, Your Honor. Yes, Lordship. The issue here, Lordship, is they have produced a fake invoice using my ex parte situation, which is nowhere linked to this particular transaction, which is exhibit.
Can it be seen now in appeal?
I'm just because it is against. I'm just requesting.
Please try to understand what is the scope of appeal.
Lordship, because if
before arguing all this.
Lordship, on page 25.
Now, what appears that you did not participate in the arbitration proceedings.
Yes, Lordship. Yes, Lordship.
And thereafter you filed 34 that
Yes,
has
Lordship.
been dismissed.
Yes, Lordship.
Now what is wrong in the order?
Lordship, we had made a.
Now you say that fake invoice and all that, whether all these facts can be appreciated here in appeal now?
It cannot, Lordship, but against public policy, they cannot produce fake invoices and make a claim. Which
All right. Is there any other ground?
That's the main ground, Lordship, and the
Thank
arbitrator.
you. Then thank you. Nothing. Dismiss. Write the order. We'll dismiss. Dismiss. We'll pass the order.
Timber.
Have you made good the deficit in the court fees? Have you paid the court fees?
Yes, your lordships. Court fees is paid, your lordships.
My lord, it is a short issue.
Your lordships, senior is in the other court, your lordships. May I seek a passover in the matter, your lordships?
Only by this
Who is
one, my
appearing
lord,
where?
the fact, my lord, the short issue is, my lord, the judgment and decree is not against this defendant. Judgment and decree is only against the defendant number 1, 2, 3. And there was a particular prayer, one of the prayer, to create the charge over the suit schedule property in favor of the plaintiff. He has been objecting that particular prayer and the contending that I have first preference on that particular aspect. He has in that regard few documents required to be verified whether the suit property is stated in his particular letter or this one, my lord. That's all. And even in the cross-examination of the DW2, my lord, he has contended that the first notice was ours and he has not issued any notice by creating the charge and interest over that particular suit property. In fact, he is having 2 other properties.
All right, let his senior come.
Lordships, it's I seek for a passover, your lordships.
Maybe, my lord, a date may be given instead of passing over, my lord. Today is a little inconvenient for me, my lord.
Lordships,
Give it. Short explanation.
Any
Short
short.
by the council for the no? Give it.
much obliged, your lordships.
I appear for the respondent.
Same matter.
Similar matters have been dismissed, my lord.
Give the detail of that appeal.
The appeal number 84 to 91, my lord. On 25-2, it has been dismissed. 84 to 91.
Ask the same order in this, and then you give the details of those.
Yes, ma'am.
Yes.
My lord, my apologies, my lord, that I'm not able to find the report, but all the action has been done. The MRI scan machine is already, the initiation of the installation is started. I have the report. The only reason why we couldn't complete it, first time they have done the bidding, the tender was called for, my lord. Only 2 companies have participated. Only one got qualified and they could not do it, my lord. They have to re-tender it again and 3 companies have come forward. Now they have they concluded with Tesla and they placed an order. Magnetic free zone is already created, the spot inspection is done, The mission is already on the way, my lord. By end of this month, it will be installed. Process has already started. I got all the papers. They given me today, my lord. Shall be filing in end of the day, my lord, before this honorable court. Because the company, Tesla company only could be finalized, my lord.
Whether the hospital has been upgraded,
My lord,
has upgraded, this hospital, DIMHNS.
that is all done. Last time I submitted. It is all upgraded. All those written form I will submit.
No,
Your
no,
lordship.
it was not done at that
My
time.
lord, as per the order of this honorable court on the last occasion, regarding MRI scan mission and the superintendent, my lord.
Which order you are referring
Your
to?
lordship, can you see 10/11/21 order, my lord?
Yes,
In that, my lord, if your lordship, shall I read it, my lord?
yes.
The affidavit of Sri Naveen Raj Singh, Secretary, Health and Family Welfare, Government of Karnataka, filed by the learned Additional Advocate General, is taken on record. We are not at all satisfied with the explanation given for the delay in implementation of the project, particularly installation of MRI scan mission. However, we have made to understand that 3 months mandatory period is required for installation of MRI scan mission, as it has to be imported from abroad, and the order for the same would be placed on 1/12/2021. Let the machine be installed and made operational on 1/3/2022, as undertaken by the Secretary, Health and Family Welfare, Government of Karnataka, in this affidavit. It is to be noted that Dimans Hospital at Dharwad was to be declared as higher psychiatric center, for which a proposal has been sent to the government. The Secretary has stated in the affidavit that the project cost is rupees 75 crores, out of which rupees 10 crores has been allocated for the year 2021. We want to emphasize on this: the hospital should be upgraded as higher
This
psychiatric.
is what we want to know.
This report also I will file, my lord. This also I will file. It is upgraded, I will file it, my lord. All those reports.
You have not done anything. Now you will do it. What does it mean?
They gave all the reports today,
Do
my
you
lord.
want the, shall we call the principal secretary again?
No, my lord, may I submit? Today they gave, because all are in different stages, my lord. I want to compile that and put it together. They have given me all the papers today, my lord. I want only 1 day's time, my lord. I will file it today. It's at the end of the day before the court, my lord. Today morning 9, they have given me all the documents, my lord.
What? This is your problem.
Yes, I understand. I will file it in the office, my lord. I'm only requesting a day's time. This is all done, my lord.
No, this is not done. When the case is taken up, then you people stand up and say that now you have received the documents, you give me given a day's time.
MRI scan machine, my lord, the tender problem happened because only 2 companies came forward to do that, and only 1 was qualified, my lord. So until at least they have a good quotations, they cannot quote them. So second time they have got 3 bidders, my lord. 1 company is finalized now. Now this is a very huge institution mission, my lord, and they require a magnetic free zone to be created, which they have done now. Everything is ready to be installed. I will give all the papers before this honorable court, stage wise, my lord.
You people will not improve. You take advantage of our leniency, and that is the problem.
My lord, so far as,
This is not done. We called the principal secretary and we recorded our dissatisfaction.
yes, ma'am.
But in spite of that, now look at it.
As for
You have not done anything. Not even a single document has been placed before us to show your bona fides.
My lord, I have filed an application for extension also, if your lordship can see. It is listed with objection.
We will reject that application.
No, that was we filed when we wanted some more time, my lord, to bring to this.
No, we will reject. We will record our dissatisfaction regarding the functioning of this department, and we will direct the chief secretary and the government to take immediate action against the principal secretary. Let him be removed.
My lord, may I submit? They wanted to even blacklist this Tesla company because they had taken the tender.
Because this is the height.
My lord, because they are not doing the installation, we are told there is an urgency. So now they started the work, all the things has been done, my lord. Only the thing is, I require a day's time to file the report. My lord, because of the technical problems, my lord, because the company has taken the tender and it took some time to revert back, my lord. That is the reason they could not install. And so far as, my lord, the medical superintendent is concerned, my lord, the qualification and the year of experience is 25. Nobody applied for the post, my lord. We called the same day, the next day itself it was notified.
Some reason or the other they give.
It is pending?
This case, my lord?
Yes.
This is is 1996, my lord. It's a running case, my lord, for monitoring the Harvard Institute, my lord. It's a PIL from 1996, my lord. And as and when the progress is happening, this honorable court is monitoring it, my lord.
What is the cost of the MRI machine?
It's almost
75 lakhs.
3.5 crores.
75
75 crores, is it?
no, 75 lakhs.
Lakhs. He says crores.
Project, total project cost is 75
Correct.
lakhs. The advocate who had filed the writ petition has reached to Supreme Court. You are still there.
It's 9.99 crores, man.
So we have recorded 75 crores project.
Project.
Right.
The mission which we have placed an order and we have the
We have not been able to make you work.
So the machine is 99 crores.
Yes, sir.
The MRI machine.
Yes, sir.
One machine.
Yes, sir. I have the.
Karnataka.
Even the supply order is 14/2/2022. We have said hospital shall be upgraded. The minimum requirement is purchasing this. We said this on 10/11/21. Then after 3 months, quotation. Quotation is after
we
3
gave
months.
3 months time to do it everything and then come.
And
then again same position.
same point.
And Tesla was finalized. The department wanted to blacklist them because they are not doing the work. Then we said there's an urgency because there's a court order. Now they have done all the things.
We have specifically said let the machine be installed and made operational by 1/3.
Yes. But first tender was a failure because the company did not come forward to do it. Only one company.
Where is that?
There's not much companies on the market, man.
Only other day in BBMP, they were also saying the same thing. Is that we made a tender, nobody applied. So simple, so innocent. Same way, you are also saying that only 2 persons applied. We understand this all.
We have the application, everything is there on record.
Yes.
That we have called for, they have applied only 2 companies.
So the communication addressed to you, MRI scan machines, the installation work, it has to be finalized, that's all.
We have already done the no magnetic zone, the spot inspection, everything. The mission is, the moment it arrives, it will be installed.
No, except-
by end of the month, they said they are installed.
But you never said that. From that time, you're only saying you want time. This is what we
End of this
wanted.
month, I said I'll file the report by tomorrow.
Not about
Today
report. This is what we wanted.
Yes, yes.
MRI scan machine is procured. It has to be installed,
It has to be
commissioned.
installed end of this month.
No, why end of the month? How long does it take? See a letter dated 5/3. The communication addressed to you dated 5/3.
Yes, sir.
Right. Site inspection for installation. Installation has been initiated. How long does it take to install and commission?
It's a huge mission, my lord. They will take end of the month.
No,
That's what-
let
because
the
I don't want
the
any last time before this court.
communication is addressed on 5/3. Right. So when was it initiated? When was it procured? When was it delivered? When was it installed? You can record this. You can record this.
They are only stating
And
28
say-
March they will conclude it, my lord.
By 28th March, let them finish this, complete this.
the functioning of these government departments. We are not understanding what is the problem. It appears that as if every responsibility is on us to see how the things are done. You people are not at all interested in doing anything. Huh? Look at it, whether in the any department we see same problem. What is seriously wrong here? I am just not being able to analyze. What is the problem? We gave you time, 3 months time now, to get this machine installed. You said that it is to be shipped and come from outside and all this much time is required. We granted you 3 months time on your insistence. Now again same position.
My lord, on 28
After 3 months again nothing has been done.
28 tenants, sir, we have invited tenders, my lord. And two
Please
bidders
don't
have
give
come.
us explanation.
No, I'm sorry, my lord, but
Please.
that's a fact, my lord.
We
And two companies, they could finalize only one, and he did not come forward. Even this company, we have to literally threat them that we'll blacklist you if you're not doing the work. Having taken the money also, man. Installment payments is also done to them.
It is your responsibility. If you don't want, close the hospital. Close the hospital. There is a question of upgradation.
When was the installation work initiated? Let us give a date and tell us when will you finish it. Communication day before yesterday says installation work was initiated, addressed to you. You give us a date. Give us a date when. Give us one date.
Why the additional advocate general is not present? On the last date he was present.
Last occasion, additional advocate general has appeared in the matter.
On his
Yes. And I
request,
informed him
we
about
had postponed the matter for 3 months.
I have informed him, my lord, in case this honorable court wants, I will.
No,
It will be pastoral.
because on the last date, the Secretary Health and Family Welfare was to appear. Therefore, the additional advocate general appeared. Now today we have not called for his appearance, therefore he is not present.
No, your lordship, kindly pastor. I'll
Now the matter has been left to you to handle.
No, my lord, I am appearing in the matter. I wanted 1 day time, my lord, to file all.
Call the additional advocate general who had appeared here in this matter. Now we will ask him what is to be done, because it was on his insistence. He said 3 months time is required for installation. We had granted 3 months time. Take up after, let him come.
Find the compliance aspect, saying that they have removed encroachment. Now, on behalf of the petitioners, we have also filed, we have done an inspection
I respectfully submit that I have taken possession of the entire 41 acres of land which was encroached upon by the 9 further state that after removal of the standing crops, possession of the land are completely secured by making trenches. My lords, remember on the last occasion, they had in fact said that they had put crops, we will allow them on a humanitarian basis to remove the crops, and my lords had in fact passed an order that this cannot, none of this can be done. Now, my lords, not only have they allowed the same people to come back and remove the crops, it is in my affidavit, my lords, can be photographed. Not only have they removed the crops, they have plowed it again for fresh sowing. My lords, can just see my affidavit and the photos that I have produced, which were taken last week. This is actually a titled affidavit on behalf of the petitioners by one B.B. Girish, and page 3 are the photos. One of the petitioners had gone with the other residents of the village of that area. At page 3, the second page shows the land is actually freshly plowed. And on the next page, page 4, even the barbed wires which were put up by these Kavaldars have not been removed. They had, in fact, within a conservation reserve, put up barbed wires to mark the territory of encroachment. This barbed wire has also not been removed. Then, my lords, what encroachment is removed? Then, my lords may see, no trenches are made, but at page 6, only one pit is done. So, there, coming back to the place is not prevented at all. And finally, my lords may just see page 7. The photo at page 7, there is a pipe. They have plowed the place. There is a white pipe at page 7. In fact, they have taken water from the irrigation pipes, these encroachers, to water their land, and they have plowed it. And this is freshly done. So it is all done in the last 1 week, my lord. It is all in collusion where they tell this honorable court that they have vacated. But they are conveniently allowed to come back, plow the land, put up their, continue with their barbed wire fences, and even irrigate it.
Lord, as per the orders of the court, possession is taken, my lord. 41 acres of land possession is taken. Photographs which my learned friend is now showing, verify on those photographs, my lord, because it is their personal spot inspection that they are claiming before the court.
GPS of each photo is shown.
In fact, I have also.
Are you aware of the order which was passed on 8th of February?
Please. But in compliance of that, this 4/2/2022 affidavit is filed to report compliance with regard to the entire encroachment being removed, my lord.
In fact, 8th February order, my lord had stated that if they are allowed to reap the standing harvest within 15 days, the Kavaldars shall reap their harvest, and in fact said that they are, that was noted.
But the affidavit of the petitioner is served on me now, my lord. I will verify this, my lord.
Good, verify.
Allowing them to, they are being rewarded for encroachment.
We direct the Deputy Commissioner to get the spot inspection and submit the report.
Independently, they got verified.
In presence of the petitioner. The court. In pursuance of the court's order dated 8th of February 2022, a compliance affidavit has been filed by the respondents. The affidavit has been sworn by one Dr. Hanumant Naik, Deputy Director, Amrut Mahal Cattle Breeding Center, Department of Animal Husbandry. As per the said affidavit, it is stated in paragraph 3 that entire possession of entire 41 acre of land which was encroached upon by the 9 Kavaldars in Basur Amrut Mahal Kaval has been taken over. And the possession of the land has been completely secured by making trenches. Full stop. The learned amicus curiae has drawn the attention of the court. Learned counsel for the petitioner has drawn the attention of the court towards the affidavit of D.V. Girish, which has been filed in response to the said compliance affidavit in order to assert that the statement given in the compliance affidavit is wrong. It is submitted that photographs have been annexed to show that the Kavaldars have made fresh plowing of the land for the purpose of sowing, and even the barbed wire fences have not been removed, which was put by the Kavaldars has not been removed. Only one pit has been digged there, and there are no trenches over the land in question. The compliance affidavit is wrong. In order to ascertain the actual position on the spot over the removal of encroachers from the land in question, and to find out as to whether the averments made in the affidavit dated 24th of February 2022 filed by Dr. Hanumant Nayak, Deputy Director, Amrut Mahal Cattle Breeding Center is correct or not. We direct the second respondent, Deputy Commissioner, Chikmagalur. Which district is this? Chikmagalur. To get a spot inspection made by an officer not below the rank of, who is next to him?
Assistant Commissioner, my lord.
Assistant Commissioner. In after giving notice to the petitioner and other stakeholders, and submit the report before the court on the next date. Give a date after 2 weeks.
23-3.
Second.
22-3. Number 9.
Here for the first respondent.
Inspector had conducted an inspection at the premises of respondent number 1, Bangalore Circular. We have based on record by November 15 to 2022. report of that inspection. The last revision, you will not have a copy of that memorandum. So it is placed for the bench now.
Have you received the copy?
I have also received a copy. Now, the report shows
Yes.
substantial compliance. Your Lordships may recall, my Lord, this is a matter relating to the running of racing activity and maintenance of horses in the turf club. A report had been called for, my Lord, by an inspector. The first report was submitted and we have my Lord, filed a response to that. After that, my Lord, the Learned Council, my Lord, for the Animal Welfare Board wanted a second inspection, and that has now been done. And as per the second inspection, a report has now been given. That report, my Lord, shows substantial compliance, my Lord. Your Lordships.
What remains to be done in this?
There were three major recommendations made by the inspector. One was in respect of upgradation, purchasing of additional medical facilities, which has been done substantially, which my report also attested. The second was the appointment of appropriate medical officer, veterinary officer, which has also been done. The third, Your Lordship, was the upgradation and renovation of stables, which has been commenced. Till date, Your Lordship, 60 stables have been renovated with the new off-panning material, which is already authorized. The remainder of the stables at paragraph 5A of the affidavit filed by.
So now renovation and upgradation work is going on, which is.
They have said that it will take another year and a half for remaining stables to be renovated. So my suggestion, Your Lordship, is that substantial compliance has been done. If this undertaking of 1.5 years, they could be bound down. We have no further comments to make.
Yes. Now, if you give this time period for the renovation and upgradation of the stables, then we can wind up this matter because substantial compliance has been done.
Please.
You say that it will be done in 1.5 years.
Yes, my Lord. That's a submission I made on oath.
So we will record this and we will finish it.
Please.
Where is the compliance?
Lord, kindly see the last report, my Lord, which my learned friend filed.
15.2.
Yes, my Lord. In that, your Lordships may go to the summary at page number 4, Lord. There's a table given, my Lord. These are the two issues on which he again inspected. The preamble there.
Inspection of Bangalore turf. You are referring to report?
Yes, my Lord. Dated inspection of the turf club on 19 January 22. My Lord. That is the report I'm referring to.
Yes.
That, my Lord, after the preamble, there is a table given there.
Yes.
Your Lordships could see the first point, my Lord, which he makes is regarding the stables. The findings are in the last column, my Lord.
Condition of stable and tracks.
Second one, my Lord, was regarding deficiency in veterinary care. That, my Lord, is at page 5. We have now appointed, my Lord, he has noticed it, the last column there, Chief Veterinary Officer.
Chief Veterinary Officer.
Yes. Then he had suggested some colic box and a sand pit that has also been done. He has reported satisfactory. Only, my Lord, he wanted an operation theatre. That, my Lord, is not really essential, but we would also like to do it, my Lord, but it will take some time, that's all. The submission that we made regarding, my Lord, the time that we require, I filed, my Lord, the affidavit to that effect.
We will note down this summary.
Yes, my lord.
And we'll say that substantial compliance has been done, and whatever remains for that, you say that it will be done within 1.5 years.
Yes, my lord, please.
All right. Third, in this public interest litigation, the
The reliefs are at page 15 of the writ petition.
petitioners have come forward with seeking following relief. The learned counsel for the petitioner does not dispute that pursuant to the several orders and directions issued by this court from time to time, a substantial compliance has been carried out by the respondents.
Number 1.
Full stop. Respondent number 1 and respondent number 2. It is submitted that the last inspection report with respect to the inspection of Bangalore Turf Club on 19/1/2022, as per the direction of the court dated 3/1/22, has been brought on record. The perusal of the same would indicate that the condition of stables and tracks has been substantially improved. The deficient veterinary care has been made good by appointment of chief veterinary officer, and the work on ground is in proposed OT complex and effluent treatment plant. Full stop. The construction of colic box, stand pit, and installation of travis in equine hospital premises, it is satisfactory. Full stop. The summary of the report given at page 6 of the report, which is brought on record by way of memo dated 15/2/2022, is reproduced below. You take down from this. Mr. Naganandan, senior advocate, appearing for respondent number 1 and 2.
1 only.
1 and 2. 1.
Only 1.
1 submits that whatever remaining work with respect to renovation and upgradation of stables would be completed within 1.5 years, and the operation theatre in the hospital, veterinary hospital, which is under construction, would also be completed expeditiously. It is also submitted that whatever the work for improvement of the Bangalore Turf Club is being carried out or is under progress shall be completed without any delay. In view of the fact that a substantial compliance have been done with respect to the grievances for which the instant PIL was filed. We do not find it necessary to keep the matter pending. It is disposed of in view of the.
Better to keep it pending.
No point. Both parties are saying.
For the petitioner, my lord.
There has been in the past prior to the petition being filed. There has been some difficulty.
We will give you liberty. If in case anything remains, you may come again.
I'm on different point, my lord.
Huh.
There has been some difficulty in getting the inspector access to the premises prior to the petition being filed.
Okay.
So we have orders passed by the Honorable Court.
We will observe that as and when required.
That is on 15/10/2020, my lord. He was appointed as the inspector.
What you have written? We do not find it necessary to keep the petition pending. The keep it pending in view of the statement given by learned senior advocate appearing for first respondent. It is to be observed that as and when required, the inspector, veterinary inspector appointed by
Respondent number 2, Animal Welfare Board.
Animal Welfare Board shall be permitted to visit the Bangalore Turf Club and monitor the various works regarding the improvement of the stables and horses.
Henceforth.
Full stop. The liberty is given to petitioner to approach the court again in case it is found that the work of renovation and upgradation of stables, etc., has not been carried out in accordance with the directions issued by this court in the earlier orders. Some time was granted to you for filing?
Yes, time, 6 weeks time was sought, my lords, on 16/12, my lords. Total corporations plus 2 municipalities. Earlier they were not parties to the proceedings. Now he has included them, my lords. But anyhow, my lords, we have collected data, my lords. Only one CMC is left out, my lords. During the course of the day, my lords, I filed. Today morning, they have all these data, my lords, pertaining to, my lords, play field, open areas and parks in these local bodies, my lords. Whether any encroachments are there, my lords, or not.
AGA informs that the relevant data and documents have been collected and the compliance report has been prepared. We will file the same, giving copy to the petitioner counsel during course of the day.
Tomorrow, my lords,
Within one day, on his request, case is adjourned today. Give a date after 1 week.
15th March.
No, this time you are fair to the court or not? Yes.
At request of learned counsel for the petitioner, 3 weeks time is granted to file rejoinder.
2 weeks.
2 weeks time is granted to file rejoinder to the statement of objections finally. Relist on date.
One day, we filed 7 petitions of similar nature. And in between one petition was liable to be dismissed. That was also first.
Gets relief, he can say similar.
Similar, everything. And he said similar. We passed the order. Subsequently, by signing, we saw that the petitions altogether different. Called him.
To 15. 2 weeks date. Up to 15. Still number. Up to still number.
Number 16. Is that fact?
Have you been able to serve respondent number 4? Served. How to know?
Learned counsel has appeared for our force.
Sure. Bipin Hegde. Let them come. Let them come. Where are they? Who appear for other respondents? R1, R2, you appearing? And K. Krishna for R3. SN Ram Prasad, R5. Bipin Hegde, R4. Yes, what do you say? Who have? Where is main grievance is against R4?
3.
R4.
R4. Correct,
Now incorporated into the VDA book, where the requirement is 22 as per the act. And now the law says, the VDA Act says, 3.
Who appears for BDA? Yes. You have to defend.
That has nothing to do with this case because this is on the basis of the VDA Act, on the violations of the VDA Act sections. I find this.
What do you want to show from this order? What do you want to show from this order?
Page number 17, paragraph 70.
Hmm.
What emerges from what emerges from the relevant clause and sections which are called out is that so far as appointment of chairman is concerned, it is purely based on doctrine of pleasure. The legislature, by bringing in amendment to 5 of the rule of 1965, person belongs to even from the field of social work, and therefore, in the present case of the time, the appointment of the responsibility as the chairman is at pleasure of the government. Even otherwise, the material on record clearly indicates that the jurisdiction Tahsildar and also experts to the video of the Bangalore Metropolitan Development Authority have recommended to consider the response number 3 for the post of chairman of the planning authority.
Catch is what do you want to rely on this? Yeah, same, bhai, barabar.
Says even the Bayappa Airport Authority.
The appointment on the basis of BDA Act.
Correct. He says the same thing, appointment of the government. So we need to look at the BDA Act, whether it is parliamentary.
That is what we are saying, that you have to defend the appointment. Kindly explain.
Objection.
Huh?
Past 4 months is at least ending. Even the last occasion, I pointed out that the chairman, both this one was avoiding the receipt of the notice itself, saying that his address.
So we will restrain him from working. We will restrain him from working if he is not cooperating. You are also not cooperating.
No, sir. Each time in that will file updates.
You have brought this order. Is what will happen?
In that matter, similarly placed authority and appointment was made. That was
Under BDA Act.
not the BD Act, not similarly placed.
That we also understand. That is what we want to know from you, as how you are relying on this. All the chairmen for you is one and the same thing in any authority, because they all are MLAs. Yes. Because that is why you feel that all the MLAs in all the corporations everywhere, the appointment is same. This is what we understand from your argument.
The Act says very clearly that the chairman, engineer member, the finance member, and the town planner members shall be all-time members. This Act says. An MLA cannot be an all-time member and chairman for the BDA. And the entire body itself is deficient with the 12 members. Even the ex-officio members have not been nominated. Any decision that is being taken by the BDA today, the present board, it is not in accordance with the law. Without having the full body, and it says shall. The Act says that section 3 says that it shall. The
Who is this petitioner?
Same gentleman is appointed as same gentleman. Same gentleman. This Mr. Vishwanath in this case.
Appointed as chairman
As
here.
chairman of
Sure. Oh, that is a common
that is
factor.
the problem.
In the Bangalore International Airport Area Planning Authority, he was chairman.
Different Vishwanath is different Vishwanath, is it?
Vishwanath is same, but that Vishwanath is not the chairman. There, respond number 3, Ravi.
Achha, chairman is Ravi. Under challenge was the appointment of Ravi.
Ravi. Here, Vishwanath is the chairman.
Correct.
Why he is party there?
He is the MLA. He has made a recommendation of that name.
Political secretary and legislator.
He had given a recommendation letter in that case, suggesting his name. Because of that reason, he was made party there.
In one case, he had himself become, in another case, he had got his friend in made chairman.
Session is taking place right now. Now he definitely cannot appear as chairman. Now he is in session. But this whole intention of
You appear for?
Contesting chairman. BD Act. The only ground seems to be that the chairman has to be a full-time member. And since he's also an MLA, he cannot be section 3(5) of the Act. He can't function as a full-time member, and therefore his appointment is vitiated. That is the main ground.
What is on that?
Section 3. The authority will not consist of the following members only: one, a chairman, one person to be called a finance member possessing qualification and accounts audit, be an engineer who should be an officer of Karnataka engineering service. But the question of full-time, clause 5, my lord, has my lord, and submits the chairman, engineer member, and the finance member, and the town planning member will be full-time member, and other members will be part-time members. On this, my lord, on the definition, my lord, I have spelled out what is a full-time member. That I will not produce it.
Where is the definition?
My lord, not in the act, my lord.
Notification, circular,
There is no
government,
notification also.
no government order.
No government order.
Then where do you get this full-time member?
It is nowhere in the act. In section 5, it is not defined. Full-time member is not defined. But the writ of covenant of my lord, only the statutory rules is violated, the writ is maintainable. Now, my lord, to show that any statutory rule is violated, it is not shown, my lord, any grounds of the merits.
Right? Sir, shall be full-time members means they shall work their contention is accepted, a sitting MLA can never be appointed as a chairman. Right. Because if there is a sitting and if the section 3(5) says that there shall be whole-time members, it means he has to be available all the time. So if the assembly is in session, he obviously cannot be available. So this requirement 3(5) will have to be read into 3(4) and 3(2). Isn't there any precedent on this with regard to under other enactments, Town and Country Planning Act, Urban Development Authority Act? I think our Urban Development Authority Act is exactly similar to this. Whatever we say will have an impact.
Okay.
There is a distinction has been made in the Act itself in section 3(4) regarding the appointment and not the nomination. There are certain class of people should be appointed.
Let him come out. Let him come with his stand. Then
My submission is that my interim order may be considered, prayer may be considered, not because the major issue here is that the body constituting BDA is not complete. 22 members should be there. At the same time, only 10 members are now appointed or nominated, either rightly or wrongly. It does not make a full body of the BDA member. Therefore, if they take any decision which is of importance, that will have its own impact and it will rise to litigation. Therefore, the present body will be restrained from taking any decision.
Will be subject to result of this.
Granting and the size and some things, it is a very important decision. A few persons cannot sit and take these decisions.
you have.
I've made a 2 interim prayers, my second prayer will be.
Firstly, my lord, we have to say how it is maintained. There is no violation of the statutory rules. According to us, my lord, there is no violation of the statutory rules. There is no eligibility criteria, my lord, this is my lord under the Act.
I have made a prayer in this respect. My prayer is confirmed and received. I have very clearly made a prayer. Issue a writ of mandamus or any other writ or direction directing the respondents to constitute and incorporate the Bangalore Development Authority strictly in adherence to section 3 of the Bangalore Development Authority, 1976, after framing the rules and guidelines to meet eligibility. It's true that there is no rules are framed for the purpose of appointment of the chairman and other members. Whoever has to be appointed, they should be appointed in a transparent manner, which is known to the law.
There is no allegation of nullified also, my lord, in the repetition. There is no allegation of nullified also in the repetition. My lord, in respect of chairman, there is no, my lord. In the Act itself, 3(2) clearly says what is the eligibility criteria in respect of other members. In respect of chairman, my lord, it is purely a document of pleasure by the government. My lord, next week, by that time, my lord, I will file my objections.
An appointment cannot be at the pleasure of the government. Because there is a distinction between nomination and appointment in the Act itself. It's been defined very clearly. Certain members has to be appointed. And your lordship can see that it's very clearly defined in the Act itself. Section 3(4). The persons referred to.
No, are you saying MLA can never be a chairman? Is that the position?
Even otherwise, an MLA
No. That's the first thing, right? An MLA is a full-time member and therefore he can never be the chairman.
As a whole time, the chairman
So you want us to hold and declare and hold that an sitting MLA can never be.
I am not specific of the MLA, but as far as this case is concerned, the present person who is an MLA sitting as
This MLA cannot be the chairman.
but
Other can be.
Other MLAs can be.
as a matter of fact, an MLA cannot be.
That's what. That's what you want us to declare.
This is what we want to. We want to know your stand. Whether you are against the MLA being appointed as chairman.
Any member of the legislative council or assembly who is holding the post, he cannot be. Because
See section 4.
yes,
No person shall be appointed or continue. So if no disqualification under section 4 is incurred by a sitting MLA, you can't you can't read that disqualification of being an MLA into section 4. Read section 4. No person shall be appointed as or continue as a member. These are the disqualifications. The MLA has to come within one of these disqualifications.
that is a disqualification clause.
There
But
is.
at the same time,
Appointment and disqualification.
191 of the Constitution of India, it is very clear that a person shall be disqualified. This is for the disqualification of the MLA. I am not touching on that point. But a person shall be disqualified for being chosen as and for being a member of the legislative assembly or legislative council of a state if he holds any office of profit under the government of India or the government of any state specified in the first schedule.
That's a different issue.
Yes, that's a different issue.
So here you will have to show under section 4(1), under section 4, being an MLA is a disqualification. Section 4. Is it specific? No.
Remain the member of the legislative assembly without attending the assembly. Without attending the assembly. There is no disqualification for MLA to be appointed as chairman. But the only requirement is that he should be full-time. So after becoming chairman, he should be a full-time chairman. Now, if suppose a MLA has been appointed and he doesn't attend the house or does any other work assigned to MLA, then he can remain the chairman. So that is why we want to know as to whether a MLA can remain a MLA without attending the house assembly. Go through the provisions. That is why we are asking. It is a question to be considered. It is a question to be considered, and you please find out what is the legal position with respect to the appointment of chairman in the development authorities in other states. Whether there is a challenge to the appointment of MLA or any other political person holding a political office to be appointed as chairman. What is the legal position?
As far as the MLA is concerned, when the Article 191 very clearly specified, though it is a different issue, wherein certain offices are
That is with respect to office of profit. For that, you will have to show that chairman BDA, after being appointed as chairman BDA, he holds the office of profit. There can be honorary post also of chairman. For that, it cannot be treated to be office of profit.
But in this case, the chairman is receiving salary. Salary is already been there, allotted in the rules also, and he is also receiving salary. He's a paid person, as well as even the rules also say so. At present,
The rule says all right, but he is drawing the salary or not? Drawing the salary or not?
but I will make my research on that.
You will have to substantiate that. Merely that a rule provide doesn't mean that he is drawing salary. He may not be drawing it. May be holding honorary post of chairman.
This post is a paid post, according to the rules.
All right, we'll consider it. Let him file his report. Mr. Hegde, appearing for fourth respondent, prays for is allowed a week's time to file the statement of objection. You have filed statement of objection. You will not file. Then counsel for third respondent as well as first and second respondent may also file the statement of objection within 2 weeks. Give it date. No, there's no. It is a PIL, no? PIL.
Thirty-one, 3. 17.
Religious site, which is marked in scheduled property, in which there are 3 idols which are century old. One idol is of 16th century of unmarked water. Then there is a Narasimha idol, which is 13th or 14th century. And there is another temple idol which is called as Sapanacharya Pratishtha Sri Raghavendra Swami.
But on the last date of hearing, I was supposed to give instructions on this matter, my lord. The lands are already been ordered to be granted to the third respondent by government order dated 24/2/2022, my lord. Section 21 of the Karnataka land grant rules for religious purposes. He is also not the resident of the remedy under is under Karnataka Land Review Act, Section 49C, my lord, since it would be a original order.
Yeah.
The order which is the government order and the grant which is.
No, but this is a PA.
Please.
Before this honorable court would be whether the state can allocate a land to any institute, any party who is on what basis the land should be allocated. This particular land is
इसमें कोई order ही नहीं है. There is no order.
it is agreed that it is a government land, but the people of residents of Italy who are praying and worshipping this three idols for centuries, and they have even managing and maintaining the land for centuries. They have even they also conduct some of the rituals and other.
Who conduct?
There is a trust by name Japata. There is a trust by name Japata Appanacharya Seva.
Where is that? Because you say you're a public spirited person.
Yes.
It is granted in favor of respondent number 3. Now, if there is a rival trust or a separate faction, that's a different issue. Then, as you said, you let the other faction has to challenge it.
But they had also sought for grant of this land.
This particular person, the petitioner, has not come on behalf of the trust.
Then why are you even saying that?
The proxy. It is a proxy.
As an individual also, because according to him, he is also a devotee of the idols.
Now, according to petitioner, it has to be granted in favor of the other trust and not in favor of respondent number 3. No.
Petitioner is not seeking granting of land to any other trust.
Then?
Petitioner is seeking that on this land should not be granted to R3.
So, you'll have to point out some illegality in the grant.
Illegality, your lordship, cannot be found in this. The matter of public policy can be discussed, your lordship. It's a PI.
When you submit a representation to the government.
Any land, especially when it is granted to any institution, it has to be some discretionary, not this.
No, where do you get that? They are saying land grant rules. Let's look at land grant rules.
Land grant rules doesn't specify the reason on which the land can be granted.
Rule 21 of land grant.
It says that the DC with prior approval of the government make land grants to religious and charitable institutions.
Right.
There is no condition on what laws they can grant.
So, if there is a flaw or a lacuna in the rule, you'll have to say that. If the grant itself is illegal, you'll have to point out Annexure C1, the illegality in Annexure C1.
Your lordship can refer to another provision of Karnataka Land Revenue Act, Section 69. There is a precedence in this matter where it was held that the power vested in exercise not only impartiality but also without ransom or prejudice in keeping in mind. It is necessary to do good to the public. And the
Sir,
society.
you'll have to read Annexure C1. You are not the rival faction or the rival trust. You are a public spirited. Right. So, Annexure C1 reads, the English translation is there. You will have to show Annexure C1 is illegal in some manner for us to interfere.
Your lordship, one of the reason
Please show us from Annexure C1.
it is not related to the illegality in the public policy. How can a government land be allocated to a trust which is 500 kilometers away? This land is for the public.
Show us some provision.
There is no such provision.
Show us some provision which says that this grant in favor of R3 is illegal. Show us some violation of some provision.
There is no such provision.
Then how do we interfere?
The enacted Karnataka Revenue Act as well as.
Sir, for us to interfere, you'll have to show Annexure C1 is violative of some provision, rule, regulation, government order, circular, etc. You'll have to show. Unless you show, we can't interfere.
Your lordship can look into one of the precedents judgment which was passed in.
Sir, you will have to give us a copy of that, sir.
Your lordship says that wherever the high of an authority if he gives an opportunity to the affected party
Correct, sir.
of being heard whenever the interest in the property is involved.
Sir, if you don't want us to say anything favorably in favor of that order, Annexure C1, then you'll have to file a representation and proceed. Otherwise, if we say that this order is correct, Annexure C1, it will affect you further. You have not submitted objections to this C1, isn't it?
Yes.
So you file objections saying, putting forth all your grounds, they will consider and then you can come to this court again.
It has gone forward, my lord. That was a proposal sent by the Deputy Commissioner seeking
Correct.
approval.
And during the pendency of this petition, it has been granted
It is
also.
already been
So we'll
approval.
record,
Approval has already been
we'll record that and we'll say that if he's aggrieved by it, let him take recourse to such remedies as available in law.
No, but that is all. Yeah.
Right. Sir, there is an order which has been passed granting the land in favor of R3 after this petition was filed. So you'll have to challenge it. And advisedly, it is better you prepare a proper writ petition and file it, rather than seeking amendment of this.
Pass the order that.
Right. In this petition, in this PIL, petitioner seeks quashing of, sought for the following reliefs. Extract. Heard learned counsel for the petitioner and learned AGA for respondents 1 and 2. Wide order dated 13/12/2021. Notice to respondent number 3 was deferred by this court. Full stop. Further, having regard to the proposed order to be passed by us, notice to respondent number 3 is dispensed with. Full stop. The grievance of the learned counsel, the grievance of the petitioner who claims to be a public spirit citizen is that the proposal at Annexure C1 proposing to grant the communication at Annexure C1 proposing to grant the subject land in favor of respondent number 3 but is unlawful, illegal and not in accordance with law, and as such petitioner is before this court by way of the present PIL. Full stop. Per contra, learned AGA submits that a perusal of Annexure C1 will indicate that the proposed grant in favor of respondent number 3 is in accordance with law, in particular Rule 21 of the Karnataka Land Grant Rules 1969, and since there is no illegality or infirmity in the proposal, the question of this court interfering with the same in the present petition does not arise. It is all further submitted that during the pendency of this petition, the respondent 1 and 2 have passed an order dated 24/2/2022 granting the subject land in favor of the respondent number 3, and consequently the present petition has been rendered infructuous. Submission of learned AGA is placed on record in view of the aforesaid facts and circumstances and the subsequent events that have transpired during the pendency of this petition, petition is disposed of as having become infructuous, and by reserving liberty in favor of the petitioner to seek recourse to such remedies as available in law. All rival contentions on merits as regards the aforesaid communication Annexure C1 as well as the government order dated so and so are kept open and no opinion is expressed on the same. Right.
An order by the first respondent.
Respondent number.
That should be followed by a DC's further order.
Right. All right. That's all.
Number 18, Joseph.
My lord, in serial number 18, my lord, the respondent number 3 has been served. Ms. Sumana Naganand, my lord, undertakes to file power on behalf of the respondent number 3. And there are two applications, my lord, IA number 1 of 2022 and IA number 2 of 2022. Both these applications, my lord, have not been served upon me. Now that I filed my wakalat, I request my learned friend appearing for the petitioner to serve 2 copies of the IAs upon me, my lord.
That was chairman. This is commissioner.
Counsel for petitioner undertakes to provide the copy of IA 1 of 22 and IA
2 of 22, my lord.
2 of 22 to Mr.
Ms. Sumana Naganand, my lord.
Sumana Naganand appearing for
Respondent
respondent
number
number 3. Give a date. The copy of IA may also be served on the learned AGA, appearing for first and second respondent.
I'm grateful, my lord.
19, my lord.
Yes.
I appear for K waiter.
Notification was issued on calling for application on 7/1/2013.
371J.
371J amendment was notified on 1/1/2013. Prior to
That is stayed, is it? Is that stayed and pending? 371J matters.
Well, that is not the point in this case, Lord. As on the date when the notification was issued and the applications were called for, the C371J was not adopted by the respondent institution. It was adopted later and it was never notified as a Hyderabad Karnataka vacancy. Just because they wanted to give one candidate, suddenly they called one person and gave. It was never notified as a Hyderabad Karnataka vacancy. Therefore, the single judge has allowed the matter, saying that the adoption of Hyderabad Karnataka to the respondent institution was on petition institution was only after the notification. Therefore, it is not applicable.
On what grounds you are challenging it?
only on one ground that the notification issued was on 7/1/2013. Subsequent to Malot's implementation of 371J. Government Malot's very specifically Malot's by an order, which is also extracted by the Learned Single Judge, states that Malot's all recruitment process initiated after 1/1/2013, 371J will have to be implemented. Any recruitment process initiated before that need not give reservation to 371J. The only dispute Malot's Learned Single Judge holds both these notifications. Malot's petitioner has contended that the notification was issued calling for applications on 28/12/2012. Although Malot's clear submitted before this honorable court stating specifically that the paper publication notified Malot's calling for applications was on 7/1/2013. That's the only dispute. That
28/12/2012 notified on 7/1.
7/1/2013.
Act, is it? Notification. Notified. Where is the notification? Annexure A, is it?
Annexure A is Malot's internal document. It was not notified to public. Paper publication was on 7/8.
Where is that document? So whether the date of notification is to be reckoned as 28/12/12 or 7/1/13, that is the dispute. Right. Shows 7/1/13. Shows 28/12/12.
Yes, we have contended in our statement of operations and the paper publication also was produced before the court, not produced in a statement of operations.
So on this issue, whether the date to be reckoned is 28/12 or 7/1, what is the finding of the learned single judge?
Both the notification dates.
We say that doesn't make a difference.
Doesn't make a difference.
Both the notification dates are
right.
paragraph
But
7.
Para 8, he says only under the subsequent resolution.
yes, that is exactly the point. They adopted it subsequently, by which time notification has already been issued and it was in progress already.
Because the dates were so close, this constitutional amendment was on 1-1. We had already notified from 7-1.
Right.
But state government directed us is ensure that reservation is granted. That's why we resort to ensure reservation is granted.
Then it is only after taking the resolution. It cannot be.
Before recruitment process was concluded, or
Nothing wrong with that. I think so.
that's the only thing.
No, there is nothing wrong.
This intra-court appeal is directed against the impugned order dated 17/12/2021, passed in WP 36710 of 2016, whereby the petition filed by respondent number 1 dash writ petitioner was allowed by the learned single judge.
Disposed of.
Was disposed of by the learned single judge, directing the appellant herein dash that is Bangalore Medical College and Research Institute to consider the case of the petitioner for appointment as medical record technician if the petitioner was otherwise eligible, and to include his name in the final selection list of medical record technician and appoint him to the post of medical record technician to the notified vacancy of GM in bracket women under recruitment notification dated 28/12/2012 with all consequential benefits except arrears of salary. Briefly stated, the facts giving rise to the present appeal are as under. The petitioner, the respondent number 1 dash writ petitioner filed the aforesaid petition inter alia contending that in pursuance of the recruitment notification dated 28/12/2012, the respondent number 1 as well as the respondents 2 and 3 applied for the post of medical record technician, pursuant to which the respondent number 1, the appellant herein notified 10 vacancies for the said post. Full stop. For the said post, out of full stop, it was contended that out of the said aforesaid 10 vacancies under general merit, 2 posts were reserved for women, and that the respondent number 1 had applied for the said post claiming women reservation as a woman. Full stop. The semicolon. The mode of selection was on the basis of written exam and interview. Full stop. Next para. It was contended by the writ petitioner that after the written exam and interview, the appellant institute published a merit list for the post of medical record technician, wherein the respondent number 1 was shown at serial number 7 and her total marks were shown as 72.05, while the private respondents were at serial number 22 by showing the marks as 63.30 and serial number 6 by showing the marks as 72.47 respectively. Full stop. Subsequently, the appellant published provisional select list for the post for the said post, wherein only 1 post of GM woman was filled up, even though 2 posts for women were reserved under GM quota. Full stop. It was therefore contended that since the respondent number 1 was the next candidate who had secured highest marks, thereby being eligible for selection under the category GM women, she submitted her objection to the said provisional select list on 21/4/2016. Full stop. It was the grievance of the respondent number 1 that even without considering her objection, the appellant herein issued the impugned order of appointment dated 25/6/2016, filling up 10 posts by providing only 1 post for GM woman, which is contrary to the recruitment notification dated 28/12/2012. Full stop. It was further contended that the notification dated 28/12/2012 did not provide for reservation for Hyderabad, Karnataka, and classification published, had also not provided for reservation to the Hyderabad Karnataka local cadre in full stop, the semicolon. In the classification, out of 5 posts meant for GM, 2 posts were reserved for women. And it was contended that after commencement of the recruitment process by issuance of the notification notifying the classification, the appellant could not have changed the classification and could not have passed a resolution dated 17/3/2016 to make reservation for Hyderabad, Karnataka, and to change the classification to provide reservation for Hyderabad, Karnataka in view of the amendment. What amendment was that? By incorporating Article 371J to the Constitution of India. Full stop. Under these circumstances, it was contended that since the respondent number 1 was eligible in all respects in relation to for being appointed to the said post, necessary directions are to be issued to the appellant to consider the case of the respondent number 1 for appointment as a medical record technician under the category GM woman. Full stop. Next para. Before the learned single judge, it was contended on behalf of the appellant that though the notification dated the notification was dated 28/12/2012, it was actually notified on 7/1/2013 and published in the newspaper on 8/1/2013. And consequently, in view of Article 371J having come into force with effect from 1/1/2013, no reliance could have been placed upon the notification dated 28/12/2012 by the respondent number 1 in order to claim appointment to the said post under the category GM woman. Full stop. Under these circumstances, the appellant herein contended that there is no merit in the petition and that the same was liable to be dismissed. Full stop. Next para. After hearing the learned counsel, the learned single judge proceeded to dispose of the aforesaid petition as stated supra by holding as under. We'll extract this. By holding as under. Full stop. Paragraph 7 up to para 7-8, we'll expect the entire things. Because you've said Supreme Court. Para 7, 8, and 9. Full stop. A perusal of the order passed by the learned single judge will clearly indicate that the learned single judge has come to the correct and proper conclusion that the notification having been issued on 28/12/2012, merely because it was notified on 7/1/2013 and published on 8/1/2013, the same would not have any impact or bearing and also would not make a difference insofar as the claim of the respondent number 1 for reservation under the category GM woman was concerned. So under these circumstances, the learned single judge has proceeded to pass the impugned order, issuing appropriate suitable directions to the appellant to consider the case of the petitioner for appointment as a medical record technician to the notified vacancy of GM woman under recruitment notification dated 28/12/2012 and by issuing necessary directions in this regard. Full stop. After hearing the learned counsel for the parties and giving our anxious consideration to the rival submissions and on perusal of the material on record, we do not find any illegality or infirmity in the impugned order passed by the learned single judge warranting interference by this court in the present appeal. Accordingly, we do not find any merit in the appeal and the same is
Much
hereby.
obliged.
Right.
Much obliged.
Number 20.
Adjourned on the request of counsel for the appellant. Give it in.
31, my lord, I am appearing for petitioner's counsel. In this matter, an application is filed for amendment of the writ petition even before notice issued to the parties, my lord, such amendment is sought for. Your lordship may kindly permit me to amend the writ petition by allowing this application. Amended writ petition will be filed and matter could be heard during next week, my lord.
The last date also you had taken time.
Yes, I have taken time to file the amendment application. Now amendment application have already been filed. It is a part of the record.
Yeah. You want adjournment?
Application. At request, right, a registry to print the name of Sri H.V. Devraju for respondent 1 to 3.
He pressed will be allowed to.
Full stop. Notice to respondents 4 and 5 deferred for the present. Private respondent.
Time
deferred for the present. Full stop. Objections to IA 1 of 22 by the next date of hearing.
If the application is allowed, he can file the objections to the in its entirety.
Sir, he wants to file objections to the IA itself.
The application I sought for is last occasion the writ petition came to be disposed of, giving liberty to address our grievance. We
Correct,
addressed the grievance that
sir,
was not.
learned counsel wants to file objections
I
to
leave
the
it to
IA.
your lordship, my lord. I leave it to you.
Number 22.
Here for the
Lord, I am for the respondent in this case, my lord.
The matter relates to withdrawal of environmental clearance by the state level environment impact assessment authority.
Lord, one submission, sorry, my lord, for intervention. Lord, make one submission, my lord, in this matter. Lord, in this case, my lord, annexure K and L. K and L, my lord, are the impugned orders passed by the respondent. Page 154. I will just make one submission, my lord. Therefore, 154 of the petition. There, my lord, we have given reasons, my lord, for withdrawal at page 158. Serial number 8. Sorry, my lord, I will just make a statement so that my lord can avoid. Serial number 8, my lord, the reasons is the PA has to seek an amendment of EC. My lord, got it, my lord?
Page 158.
158, serial number 8. The compliance regarding compliance with regard to objections by the joint committee.
Yes.
Serial number 8, my lord, the PA has to seek, project authority has to seek an amendment of EC for quarry lease number 358 as the EC issued for 3 acres and quarry lease issued for 2 acres. Next comment kindly see, till date, the project authority has not applied for amendment of EC. If they apply, we will consider afresh within 6 weeks. Both the orders.
There are two orders.
Yes, the same
It
reasons
applies only to ML 358. Now for the other also they give the same reason. There are 2 binding leases. One is ML 358, another is 371.
Both afresh.
But now set aside annexures K and L.
Yes,
annexure L, Lord, they say for 358. The same reason cannot be made applicable for 371, ML 371. They give same reason for 2 mining leases. There are 2 mining leases, 3 acres each. One is mining lease 358, another is mining lease 371. All conditions have been complied with. If it is for 358, I will have to apply for modification. That reasoning would hold good. But what about 371, my lord? I have complied with everything. There is no modification. So far as 351, initially for 358, initially it was for 3 acres. Later on, it is reduced to 2 acres. They say for 2 acres, you will have to apply. We have already applied. But they refer to the same reasoning for 371, which is that annexure K, which is an independent mining lease for 3 acres, no modification of the extent in 371. All other conditions have been complied with.
So annexure K will have to set aside on the ground that the reasons assigned are incorrect.
Yes.
Annexure L will have to set aside and say reconsider.
Yes, Lord.
In this petition,
On instruction, my lord. I am making submission on instruction.
sorry?
On instruction, I am making submission, my lord.
Right. All right. Shri D. Nagaraj accepts notice for the respondent. Stop. Heard Shri Ashok Harnalli, learned senior counsel for the petitioner and the learned counsel for the respondent, and peruse the material on record. Full stop. Next para. In this petition, petitioner seeks quashing of the impugned orders at annexures K and L dated 2/12/2021 and for other reliefs. Full stop. In addition to reiterating the various contentions urged in the petition and referring to the material on record, learned senior counsel invited our attention to the impugned order at annexure L dated 2/12/2021 in order to point out at serial number 8 in the table, in the serial number 8 in the serial number 8 at paragraph 40 in the table contained at paragraph 14, comma, the reply statement, the reply statement by the respondent indicates that the extent of quarry lease of ML number 358 was 3 acres in survey number 166 bar P1 of Shivpura village, and that the Department of Mines and Geology reduced the said extent of mining area from 3 acres to 2 acres. Full stop. It is further stated in the said reply statement, the Department of Mines and Geology has rectified the change in the lease deed and have not informed the the EC clearance should be reduced to 2 acres. Full stop. Accordingly, the modified quarry plan as per the KMMCR rules 1994 has been submitted to the DMG and and it is approved, and that in this regard the EC clearance is not released due to the fact that the matter is before the Honorable NGT. Full stop. It is submitted by the learned senior counsel that the aforesaid statement made by the respondent authority with regard to mining lease bearing number ML 358 is not applicable to mining lease bearing not applicable to mining lease bearing number 371, which is the subject matter of the impugned order at annexure K dated 2/12/2021. Full stop. It is therefore contended by the submitted by the learned senior counsel that the reasons assigned by the respondent authority at serial number 8 of paragraph 14 of annexure K are illegal and contrary to law, and the same deserve to be quashed. Full stop. Insofar as the impugned order at annexure L is concerned, comma, it is submitted that the appellant, the petitioner, had submitted a representation.
No, we have submitted for clearance for reduced extent.
They submitted a clearance for reduced extent of about 2 acres as stated in the aforesaid reply statement by the respondent authority, and consequently the said in submit madadre
the application for
application
environmental clearance for reduced extent.
The said application for reduced extent may be reconsidered by the respondent authority by setting aside the impugned order at annexure L also. Next para. Per contra, on instructions, learned counsel for the respondent submits. In Nagaraj, what do we say?
Insofar as Lord, the reason stated in respect of mining lease 358 is concerned, Lord, if since they have submitted a modified plan, modified extent, we will reconsider.
Right. Submits that if the petitioner has submitted an application for the modified extent, which is subject matter of the impugned order at annexure L dated 2/12/21, comma, the respondent authority would reconsider the same in accordance with law if reasonable time is granted to do so. Full stop. Insofar as the impugned order at annexure L dated 2/12/21 is concerned, comma, learned counsel fairly submits, but that the reasons assigned at serial number 8 of the reply statement at paragraph 14 are incorrect and are not applicable to the subject matter of the said lease
That is
bearing
for
ML
Annexure
number
K, my lord. That is for Annexure K.
Annexure K, sorry, Annexure K, dated 2/12/21, ML number 371, full stop. Submission of learned.
Quarrying lease.
Huh?
Quarrying lease.
ML alva? QL. QL. ML, QL, correct. QL 371. Correct. Right. Next para. Submission of learned counsel for the respondent is placed on record. Full stop. In view of the aforesaid facts and circumstances and material on record, comma, as rightly contended by the learned senior counsel appearing on behalf of the petitioner, comma, the reasons assigned by the respondent authority at serial number 8 of paragraph 14 of the impugned order at Annexure K dated 2/12/2021 are erroneous and incorrect and contrary to the material on record, inasmuch as the subject matter of the said subject matter of the impugned order was quarrying lease number 371 and not ML mining lease ML 358, which has been referred to in the impugned order. Full stop. Under these circumstances, we are of the considered view that the impugned order at Annexure K, being illegal and opposed to the facts and probabilities of the case, the same deserves to be quashed. Next para. Insofar as the impugned order at Annexure L is concerned, comma, in view of this, in the light of the specific submission made on behalf of the petitioner, that the petitioner has submitted a representation for mining lease to the in relation to the reduced extent of 2 acres, comma, we deem it just and proper to set aside the impugned order at Annexure L dated 2/12/21 and direct the respondent authority to reconsider the claim of the application / claim of the petitioner in accordance with law within a period of 6 weeks from the date of receipt of a copy of this order.
Right.
Subject to the aforesaid directions, petition stands disposed of.
Number 23.
I appear for the respondent.
For the petitioner, repetition 51 of 2013.
Yes.
For the petitioner in the connected matter, WP 13476 of 2013.
Yes.
As the petition is filed, challenging the allotment letter and the CS site lease agreement and the possession certificate issued by the Bangalore Development Authority to respondent number 4.
Is there any urgency
Who
today?
is a
Matter is fixed for hearing.
no,
We'll hear the matter on some other
Yes.
date.
Right.
Please, minutes.
Yes,
List
yes,
again. List again on itself for final hearing.
34. Number 24.
Let's, I am for the impleading applicants. I have filed 3 impleading applications. There are 2 office objections for that.
Let
I
the
will comply
application
then.
for impleadment. Let the application for impleadment be considered on the date fixed. Yes. Pass over.
Number 25. So Yogesh K.
Along with the document.
Or impleading proposed respondent. Counsel for the petitioner applicant wants time to furnish the translated copy. On his request, case urgent. Give a date after 2 weeks.
24th March.
We can direct issuance of notice to proposed respondent.
ट्रांसलेटेड कॉपी ऑफिस में ऑब्जेक्शन लगा रखा है
We have produced, permitted to produce document from the report of the auditor and control.
You file the translated copy, will consider. Yes, pass on.
Also matters number 7.
MRI machine. When was it
On the
installed?
last date, we had the officer had present, so you appeared.
Yes,
Just because that principal secretary was appearing, so therefore you appeared. Yes, and not today. You did not have the courtesy to appear.
I'm so sorry, it is not
Hmm?
any wrongful intention of not appearing before your lordships.
Yes.
So I,
Now, on your saying that the machine is to be imported and it will take 3 months' time to be installed and made operational, we granted you 3 months' time.
yes.
Now, what has happened?
Now, Lord, I'm told the first tender failed because there was only one tender.
No, forget, I'm sorry. Forget all that. The correspondence day before yesterday says the installation work has been initiated.
Yes.
When was it delivered? When was it initiated?
No, the equipment is on its way from the US.
But this communication is wrong, is it?
The installation, my lord, is for the entire room. It has to be demagnetized. There has to be a demagnetized room into which, my lord,
So the site is getting ready.
the site is getting ready. I'm told, my lord, by 15th of April, it will be the
Delivered.
first patient will start what the entity who has been awarded the contract has informed us.
What is to be done? That on your saying we granted you time, and in spite of that, nothing has worked out. What is to be done now? How to make your government work?
Send it to Ukraine.
Because
Sometimes I wish I could away from this. I was happier on the other side.
now look at it. Now this is 1996 writ petition,
Yes.
and the council who had filed the petition has reached to Supreme Court, and you people are still not performing. We will have to send this matter to Supreme Court before her only to see the things in Karnataka. Do something from there, because here we are unable to make them work. That is the height. Now, what has happened to upgradation of the hospital?
There is further facilities for which money is required, but it's already a higher psychiatric center.
There is no document to show that. We wanted to emphasize that this hospital shall be upgraded as higher psychiatric center at the earliest, as the government itself has announced to upgrade it.
Yes.
The delay due to lack of funds or any other reason cannot be accepted. Therefore, we hereby direct that respondent shall make the hospital at Dharwad function as higher psychiatric center as per the norms fixed in this regard, and shall take steps so that it may be made operational from 1/3/2022. Now, 1/3/2022 has still the same position exists.
The MRI machine will not, I think, by April.
There has to be some responsibility of somebody. Now, how much time you want to for making it? What you were saying, 2 weeks?
Sir, there is one schedule, time schedule they have given. Can you file an affidavit?
Yes, yes, we'll file that.
as per the
General appearing for the respondent informs that the work for upgradation of the DIMHANS hospital at Dharwad as Fire Psychiatric Center is in progress. The MRI machine is being transported from US and a schedule has been given to complete the various works, according to which the entire work would be completed by 30th of March 2022, and the hospital will start working as higher psychiatric center. First of, on his request, case is urgent today. List on, give a date in the first week of April. 5/4/2022. The schedule of work to be completed. Regarding the schedule of work to be completed, an affidavit shall be filed, and the respondent shall ensure that the hospital starts functioning as higher psychiatric center from 1st of April 2022, failing which the principal secretary medical education secretary health, what is the disease
medical
shall appear on the next date. We wanted to make you realize that you appear only for officers. Yes. Not for the government.